Welcome to the 21st lecture of this lecture series on international arbitration practice. In the past two lectures, we have been dealing with the preliminary aspects to consider prior to issuing a notice of arbitration. In the 19th lecture, we dealt with the aspects to be examined before invoking arbitration, and in the 20th lecture, we discussed a practical example and applied the checklist. In this lecture, we use the same problem and draft a part of notice of arbitration. We will continue with drafting it in the next few lectures. To recap, we summarize the facts. December 2021, agreement between client, which is an Indian party, and Indian subsidiary of a Singaporean parent. 1/1/2002, commencement of work under contract. 30/4/2022, two milestones have been completed. 5/5/22, that is by 5/5/22, client had paid 2.5 crores towards two milestones, that is 10 plus 15 milestones. May 22, another client failed to make payment to the contractor. Inability to deploy workforce for the present contract is a consequence. Failure to complete the contract by February 2023 would mean failure to meet deadline of top management of client and lesser performance related pay for client's branch. Repeated request to contractor to complete the work failed and the contract failed to respond to it. 10/5/22, technical department approaches in-house counsel for solution. The solution for the client is to issue a notice of termination with a warning that failure to commence within 2 weeks would lead to termination and risk and cost contracting. On 10/5/22, that is the same day, letter regarding termination was issued by fax, email and post. There was no response to the letter and therefore the client terminated the contract on 25/5/22 and informed of risk and cost contracting. The client also encashed the bank guarantee of ₹1 crore, that is 10 million, and it floated another tender. On 30/5/22, bids were received under the tender, and on 31/5/22, the lowest bidder who quoted 10 crores, that is 100 million, for finishing the balance 5 milestones was awarded the contract. The contract was to commence on 1/6/22 and was to be completed by 31/3/23. On 1/6/22, the letter was issued to the original contractor that risk and cost contract had been awarded and the difference in price along with supervision and establishment charges would be recovered from the original contractor. A total of ₹2 crores is sought to be recovered. So, for detailed facts, kindly look at the fact sheet. The link to the fact sheet is in the comments to this video. Kindly retain the fact sheet throughout the lecture series as we are going to explain various practical aspects using the very same problem. Note that we have used a very simple problem to aid in explanation and for ease of understanding. Now let us come back to the problem. You are ready with all the facts, papers, and now you want to draft the notice of arbitration. You have all the papers with you and you start drafting. There are many ways with going about drafting the notice of arbitration. Broadly, there are two approaches. A. Letter format and B. Pleading format. The letter format is predominantly used in India in commercial arbitration matters, while the pleading format is used in large international commercial and investment treaty arbitrations. We are mostly familiar with the letter format and we are going to see one in a short while. Table of contents of a sample notice of arbitration in the pleading format is given here just so that we understand the structure of it. Notice how the pleading format is structured. It is not lengthy but encompasses the parties, the factual background and the breaches of the agreements in the treaty. Then it describes the arbitration agreement. After this, it deals with the number of arbitrators and the nomination of the claimant's arbitrator. Lastly, it deals with the relief requested or sought in the arbitrations. Since ours is a relatively smaller commercial arbitration matter, we use the letter format. In one of the later lectures in this chapter, we will definitely discuss the pleading format. Now, Coming back to our problem, before you start drafting the notice of arbitration, see if the arbitration agreement provides for institutional rules applicable to the arbitration. In our case, as noted in the fact sheet, institutional arbitration has not been chosen. Rather, it is an ad hoc arbitration by the chairman and managing director of the client or his nominee. We had discussed in the last lecture that the in-house counsel of the client had advised a neutral arbitrator to be appointed. The notice of arbitration should accordingly provide so. If the institutional rules are applicable, you must read the rules and examine what they state regarding the notice of arbitration. Let us take the case of SIAC arbitration rules and see what they state. Rule 2 deals with notices and communications generally. 2.1. For the purposes of these rules, any notice, communication, or proposal shall be in writing. Any such notice, communication, or proposal may be delivered by hand, registered post, or courier service, or transmitted by any form of electronic communication, including electronic mail and facsimile, or delivered by any other appropriate means that provides a record of its delivery. Any notice, communication, or proposal shall deem to have been received if it is delivered 1. To the addressee personally or to its authorized representative, 2. To the addressee's habitual residence, place of business, or designated address, 3. To any address agreed between the parties, 4. According to the practice of the parties in prior dealings, or 5. If after reasonable notice none of these can be found, then at the addressee's last known residence or place of business. 2.2. Any notice, communication, or proposal shall be deemed to have been received on the day it is delivered in accordance with Rule 2.1. 2.5. The party shall file with the registrar a copy of any notice, communication, or proposal concerning the arbitral proceedings. Rule 3 concerns the notice of arbitration specifically. It is lengthy, but we quote it. A party wishing to commence arbitration under these rules, the claimant shall file with the registrar a notice of arbitration which shall include a demand that the dispute has been referred to arbitration, b. the names, addresses, telephone numbers, facsimile numbers, and electronic mail addresses, if known, of the parties to the arbitration and their representatives, if any, c. a reference to the arbitration agreement invoked and a copy of the arbitration agreement, d. a reference to the contract or other instrument, example investment treaty, out of or in relation to which the dispute arises, and where possible a copy of the contract or other instrument, e. a brief statement describing the nature and circumstances of dispute, specifying the relief claimed, and where possible an initial quantification of the claim amount, f. a statement of any matters which the parties had previously agreed as to the conduct of the arbitration or with respect to which the claimant wishes to make a proposal, g. a proposal for number of arbitrators if not specified in the arbitration agreement, h. unless otherwise agreed by the parties, the nomination of an arbitrator if the arbitration agreement provides for 3 arbitrators, or a proposal for a sole arbitrator if the arbitration agreement provides for a sole arbitrator, I. any comment as to the applicable rules of law, j. any comment as to the language of the arbitration, and k. payment of the requisite filing fee under these rules. 3.2. The notice of arbitration may also include the statement of claim referred to in Rule 20.2. 3.3. The date of receipt of the complete notice of arbitration by the registrar shall be deemed to be the date of commencement of the arbitration. For the avoidance of doubt, the notice of arbitration is deemed to be complete when all the requirements of Rule 3.1 and Rule 6.1b, if applicable, are fulfilled, or when the registrar determines that there has been a substantial compliance with the requirements. SIAC shall notify the parties of the commencement of the arbitration. 3.4. The claimant shall, at the same time as it files the notice of arbitration with the registrar, send a copy of the notice of arbitration to the respondent and shall notify the registrar that it has done so, specifying the mode of service employed and the date of service. This is a detailed clause and can be converted into a nice checklist. We'll do it later. Now, let us start off with drafting the notice of arbitration in our problem. Lawyers typically start to draft a notice of arbitration in the letter format from the main content or from scratch. So there are two approaches, but we'll do it the latter way. First, any letter would start off with a reference number and date. Reference number contains the details of the file or correspondence number, etc., mainly useful in connecting the document with the records and or the department of the party invoking arbitration. Then the date. Once these things are done, we start with an important aspect, name of the parties. In our case, we are invoking arbitration under the agreement against both the Singaporean and the Indian parties. We are going to use the agreement signed with the Indian party. The important aspect is address. Assume that you have entered into an agreement which provides for the address of the parties to which all communications would be given. The notice provision, as such a clause is called, would also provide the manner of issuing notices. Here, the client is planning to drag the Singaporean parent also. But the notices provision in the agreement may not explicitly list the address of the Singaporean parent. It is possible that since signing of the agreement, the party may have moved to a different location after or without informing the client. It would be better to amend the agreement immediately in such a case. To prevent defects in service and later objections regarding the failure to serve the notice of arbitration to the correct address of the respondents, you can do the following. Use the agreement provided address for the Indian subsidiary. Check their latest communications and website. If a different address is used, address your notice to that address as well as in addition to the address specified in the agreement. Use the last communication with the Singaporean parent for the address. In addition, check its website and find out if a different address is mentioned. In that case, use that address in addition to the ones mentioned in the last communication. The above approach is to be followed for email and fax too. Then the subject is stated. It would be notice of arbitration under article dash of the agreement number 124 of 2021 on design automation of engineering components for power plants. Once you are done with the subject, references is important. A tip here, in the fact sheet you would notice that a notice of termination was sent to the contractor on 10 May 22. The contract was terminated on 25/5/22 and a demand letter was sent on 1/6/22. Make sure that the notice of termination and the termination letters list out the correspondences or documents relied on under the head references. So, should the demand letter. At the end of the list, you may add a general reference to correspondence and communications. This will help in identifying correspondences or communications relevant to the issue. You need not crowd the notice of arbitration with listing out all the references. You would have already incorporated them by referencing the demand letter dated 1 June 2022. So, we are done with drafting the formal part of the notice of arbitration. We need to address drafting the substance of the notice, which we will do it in the next lecture. Bye bye and stay safe.